and we're going to look at the slide deck. It was very inspirational, thanks to your host.
So, hello everyone. I hope you all are doing well. My name is Muhammad Shaheer. I am a second year law student and I will be serving as the moderator for today's session. This session is being conducted under the Legal Hubs community. Legal Hub community is a Pakistan based platform built by law students and young lawyers to make legal education practical, accessible, and career focused. We offer free webinars, hands on legal training, case law updates, and competitions to help students grow beyond the classroom. Our mission is simple: to build confident, skilled, and ethical legal professionals ready for the real world. The topic of today's session is mediation as the future of dispute resolution. Mediation is increasingly seen as the future of dispute resolution because it emphasizes collaboration over confrontation. It allows parties to resolve conflicts in a cost effective, time efficient, and less adversarial manner compared to traditional litigation. By fostering open communication, mediation helps preserve relationships while addressing underlying issues. It also offers flexibility as solutions are tailored to the needs of the parties rather than imposed by a court. With growing recognition worldwide, mediation is becoming a cornerstone of modern judicial system. Now, I would be honored to introduce our speaker, Miss Kathleen. Miss Kathleen is a certified mediator and global mediation trainer with roots dating back to 2008 at the Justice Center of Atlanta, an institution established under President Jimmy Carter's initiative, and at MWI in Boston, MA. Her professional journey spans 17 years and includes more than 500 hours of specialized training in civil, elder, family, and divorce mediation across 7 states. She has facilitated over 1,000 court and private practice cases and have taught the mandatory 40-hour basic mediation course since 2017, now in 20 US states and international jurisdictions. Her approach to mediation combines rigorous professional training with practical experience. Each case presents unique challenges requiring careful attention to detail and a thorough understanding of legal frameworks and human dynamics. Through her practice, she has consistently demonstrated that even the most complex disputes can be resolved through structured professional mediation. So we would be taking your questions in the last. You need to write down it in the comments. I would not waste a minute more. I would like to hand over the stage to Miss Kathleen. Ma'am, the floor is yours.
Thank you so very much for that kind introduction. And I'm really enjoying the title that you wanted for this particular training today. A lot of people do see mediation as the future of dispute resolution. It's gaining lots of acknowledgement and success across the globe. When you look at mediation as your future, as well as you are a law student looking at your future in law, and right now, soon, in a couple of days, the big mediation tournament, very large, 65 teams last year when I was there in Vienna, is actually getting ready to commence. When you look at being in law school, where you have a loyalty to the rule of law and memorizing the rule of law and understanding the procedures of how justice is pursued within that system, mediation also aligns itself with justice, and mediation is focused more on the person, the rule of the person, not the rule of law. So as law students, I think you have the best future of being the greatest mediators ever because of the fact that you are learning both together. And it's the togetherness of running the mediation process, because mediation is a process which equals structure, the law, structure, the process, plus flexibility, the human, flexibility, you, the mediator, flexibility of how you use the structure of the process. So I think it's all very exciting. And this ADR overview is because alternative dispute resolution appeared in the United States as well as other countries because there was an overload of cases in the courts. And in the United States, there was a focus, how else can people resolve their issues? But it actually pulls from ancient traditions of villages and people sitting around restoring people back to the community after something had happened. So this is the concise introduction to how alternative dispute resolution, alternative to the courts, alternative to arbitration happen. People are looking for their justice. And within the modern legal systems, this focus of mediation can be inserted at any place. Pre-trial, you can have the mediation procedure. Before pre-trial, you can have the mediation procedure. Before a case gets to court, you can have the mediation procedure. In the middle of a case in court, you can have the focus of mediation. A stayed arbitration can give space for people to go to the mediation table and collaborate. So all these legal systems across the globe have a place for mediation if they want to insert it. And with the Singapore Convention, where we have commercial mediation agreements passing through countries without being remediated or relitigated, you can see the dovetailing, the beautiful dovetailing of how mediation can fit anywhere. It can change and be shortened, to be lengthened, to fit in any place involving business, involving divorce, involving family relationships, involving commercial agreements, involving everything. It just takes the focus of the country, the city, the town, the village to decide they want to implement and what place do they want to implement. There are places in Canada and the United States where law students in law schools right now are mediating court cases in their law school, in a designated spot in their law school. And so this is a relationship. When we look at efficient collaboration, it's a relationship. Who, when, where, how does mediation happen? So I'm looking forward to seeing the further growth of this relationship. In my personal life with Teen Mediation International, TMI, we are looking to put mediation skills into refugee camps with teenagers. And mediation skills have been in place, peer mediation in the schools in the United States, in elementary school, in middle school, and high school, where fellow students are helping each other mediate conflicts. We call it peer mediation in the United States. And that's been here for generations. And so this is the efficient collaboration of how do we lower conflict somewhere, somehow, including in our own lives. This is what we're looking for efficient collaboration. So these mediation tools that I will put into the chat at the end of my speaking also are activated in your personal life if you want them to be. Because mediation is a process, the structure of mediation is important. Number one, the structure of neutrality, that the mediator does not have undue influence over the decision making. It's very clear in facilitative mediation, which I'm speaking about today, not adjudicative style mediations, not evaluative style of mediations. There are different forms of mediations. Today is facilitative, where we remain impartial, we remain neutral. We say neutrality in the United States. Around the world, the word impartiality is used. They mean the same thing. The mediator is a third party, non-biased, non-prejudiced person sitting at the table, running the process. We are in charge of the process, And people at the table are in charge of the decisions. The way we allow people to be in charge of their decisions is neutrality. The way we allow people to have equal speaking time at the table is neutrality. How much I speak to one person and then how much I speak to the other person is running a neutral process as well, is neutrality. And in my mind, inside of me as the mediator, not leaning toward or away from someone with bias of thinking or prejudice in my behavior towards someone or away from someone is the expression of my neutrality. The mediation conversation is also highly confidential. My confidentiality is likened unto the confidentiality of a judge. There are not too many situations in all of the globe where anyone can force a mediator to disclose the conversation and the decision-making at the table. Confidentiality of people at the table, where they have a confidential conversation together, all of us sitting together in what we call a conference session or a joint session, is confidential as well, with an extra layer of confidentiality if you sit alone with me as your mediator. I promise not to disclose anything in a private room between you and I with the other person, other people at the table without your exclusive permission. These are called principles of mediation: neutrality, confidentiality, now moving into voluntary participation, which is common across the globe for mediators and the participants. In most situations, not all, not 100%, a mediator can walk away and say, I don't want to mediate this case anymore. In most situations across the globe, people can walk away and say, I don't want to sit here and have this conversation anymore. That's party autonomy. And party autonomy is also in the decisions that people make. The final decisions, called self-determination, people will determine themselves using their own autonomy. What do I want to agree to? What do I want to counter offer to? What kind of offer do I want to make? What do I not want to agree to? What do I want to make a counter offer about because I don't agree to this offer that I'm hearing from the other people at the table? These are the principles or fundamentals of mediation that we actually speak about in our mediator's opening statement before the mediation commences. We explain all of this to people so they understand. Remember, I said the process, people understand the process here today at the table, the principles of mediation here today at the table that are the overarching ethics of the table are neutrality, confidentiality, voluntary autonomy, and self-determination. These are the overall arching ethics that as a mediator, I have to make sure these ethics are alive and well at my table, as well as describing the process here today at the table. What's going to happen at the mediation exactly at the table. These essential skills, tools that we have as mediators benefit you as law students. A lot of what you're doing in law school is you're communicating, you're verbally speaking aloud, your word choices, how you structure your sentences, your tone. Your voice has three tools. Your tone, you either like my tone right now or you don't. It's not your personality, it's just the response of your biology. Your voice can go up or down, lower. That is the pitch. And you can talk really fast, like this, really, really fast, and talk about communication, negotiation, problem solving, emotional intelligence, or you can slow down the pace of your voice and speak more deliberately, which is more cooperative and not as competitive as talking this quickly like this. So you have voice tools. And as mediators, we learn how to use the three tools in our voice: our tone, our pitch, and our pace of voice. Your communication style is important. The negotiation tools that you learn At the facilitative table, we negotiate from clarity and accuracy. In law school, you learn about negotiation from strategy. Adjudicative lawyer type mediations negotiate from strategy. Well, facilitative table mediations negotiate from clarity and accuracy. Facilitative mediators are always, as I like to say, chasing clarity and accuracy within the communication, within the negotiation, within the problem solving, using our emotional intelligence of ourselves and other people at the table to chase the clarity and accuracy always at the table, no matter what stage of the mediation we're in. Negotiation is last at the facilitative table. So we are chasing, as the mediator, running the process, clarity and accuracy in number 1, communication. Clarity and accuracy in the brainstorming, number 3, of writing down creative solutions to resolve the table today. And we're chasing the clarity and accuracy of how are people thinking at the table. We're building empathy, but we're also have self-awareness of how people are thinking. How are they processing this information at this table and putting it in order? That's what we're doing. We're doing 1, 3, and 4 before we ever get to number 2. At the facilitative table, negotiation is last. We want the full effects of chasing clarity and accuracy with number 1, number 3, and number 4 before we ever provide the opportunity for people to join hands in the stage of negotiation. Just like the logo looks, negotiation is them and them. Chasing community and clarity and accuracy at the table is 1, 3, and 4, is you as the mediator and them, you, them, and the process before we get to negotiation. Lawyering, you learn to negotiate very quickly. What are the strengths and weaknesses of your case? That's a soft negotiation. We hold off on that. So these mediation skills of chasing the clarity and accuracy of the backstory, brainstorming, and what feels right to people, emotional intelligence, and building empathy and self-awareness for people at your table has to do with the feeling of justice or the feeling of injustice at your table. How does the justice feel to people? How does the injustice feel to people? We chase all the clarity and accuracy of 1, 3, and 4 before we ever go to number 2, negotiation. These are the practical applications of mediation. No matter the arena of the mediation table, commercial and civil, high dollar, high stakes, C-suite, corporate, countries, political, it's still resolving issues. It's resolving issues that hopefully are long-lasting resolutions that work effectively, that people can come back to the mediation table and redo some of the meaning of the mediation, because in the future it took a change. These practical applications of mediation, whether it's commercial and civil, family and community, workplace disputes, or mutually beneficial relationships, always begin with historical chaos. There's chaos. And because the chaos involves emotions as well, oftentimes anger, disappointment, loss, grief, chaos is disruptive. Even if it's civil, commercial litigation, something disruptive has happened. There is a problem that needs to be resolved. This historical chaos moves through the mediation process. And the mediation process gives people stages and time to reorder this chaos, to create new meaning as people communicate with each other, brainstorm solutions. We get to the interests and needs of the position as well. New meaning gets created, and out the back end of the mediation table comes a document created with new meaning, usually, or preserving historical meaning that came to the table. No matter, all these practical applications are about meaning. What's important to people? What is not important to people? On a scale of 1 to 10, how important is this to people at the table? Mutually beneficial understanding of the relationships.
Sorry,
Go ahead.
Miss Kathleen.
Mhm.
Sorry to interrupt you. Actually, your slides are not moving. Your slides are
That's
not moving as you are
that,
talking and changing
that's
the topic.
correct. That's correct. This slide is not moving yet. Now I'm going to move the slide. Do you see the slide move now?
So,
Go ahead.
no, no,
Do you see professional scope and ADR careers?
no.
Okay, let me stop sharing. Let me go ahead and share again, see what happens. Thank you for telling me. I'm going to present again at the bottom. I'm going to share my screen. And I'm going to go back to deck. Do you see professional scope and ADR careers now?
The screen is loading. Just a bit.
Okay. My connection is good here. I have all 5 bars.
No.
Oh,
Still,
would you like to?
The title screen is showing that mediation as a future of dispute.
Would you like to share the deck yourselves? And I can speak when you share the deck.
Okay, share it with Miss Humaira.
Okay, let me go ahead and put it into the chat.
Miss Humaira. I will share it from my side. She will send it.
Yeah, let me go ahead and put it into. I've already shared it. Let me share it one more time in the chat itself. Copy the link and put it into the chat right now. Let's see, where's our chat? There it is. I'm going to put it into the chat. Will that work?
Let me see.
There we go. Let's go ahead and move it forward one.
Which slide do you want to open? Slide number?
I'll just go very quickly, just recap just a little bit. So this is the introduction to ADR and mediation that I was talking about. It really can be dovetailed anywhere. It's just a matter of people in authority finding a place. As I mentioned, law students in the United States and Canada are mediating court cases from their law school, from a designated room in their law school on Zoom. So this introduction, why the courts were overrun in a country and needed a different way of having quick justice, that's where mediation was birthed in the United States. We need to add something else for people to be able to pursue their justice quicker and easier than the court process, quicker and easier than the arbitration process. Let's move to the next slide, please. And these fundamentals of mediation across the globe, these are the principles of mediation. Across the globe, mediation is about neutrality, impartiality, confidentiality, voluntary, party autonomy, and self-determination of making their own decisions. In the United States, sometimes we add some extra principles depending upon the state, because mediation is at the state level, in the state level courts a lot. And we may add people need to mediate in good faith. Like, for instance, Washington State, you have to add that to the fundamentals. In different countries and different states will do the same thing as well. Next slide, please. And I was talking about these skills that you can add to your personhood as you are in law school and you are engaging in mediation tournaments in your ADR society, hopefully in your law school. You will learn more tools that you can add to your skills as a lawyer. When I train judges and lawyers around the globe to become mediators, I'm telling them, you're not bringing your skills to the mediation training. You're going to bring your mediation learning tools to your law practice, to your mediation practice. And you are going to have many more tools and skills available to handle the high conflict, because I'm a facilitative mediation trainer, and that's our specialty. We talk to the emotional element at the table. We talk to the logical element at the table. We talk to the creative problem-solving elements at the table. So please, I urge you to participate in these mediation tournaments as soon as you possibly can. I think the greatest mediators should be lawyers that have learned the facilitative skills, because I'm not a lawyer. I can't take a 40-hour class and become a lawyer. You can take a 40-hour training and become a mediator. I can't do that. That's why I think lawyers are going to be the greatest mediators someday, when these skills become enveloped and accepted by lawyers and judges. Thank you. Next slide. The practical applications is where we left off. And this is where, no matter the venue, you're a mediator. You run the same process. Yes, a different story. Yes, different facts. Yes, different kinds of people. Same process, same process, same process. You become an expert in the process. I've done construction type mediations in the past. That's not even on this list. Construction, building buildings and moving dirt around and building villages and all of that. Turbines, offshore, wind farms, onshore. These are just different venues, and it's okay. The mediation process is the same. The settlement agreements are all different, and people have different stories at the table, but the mediation process is still the same. That's the practical application of being a mediator. Doesn't matter what venue you sit at. Maybe you prefer the high commercial civil mediations that are usually non-emotional. Okay, but when you reach an impasse, it's going to get a little bit emotional. So you're going to be using your tools. Different venues, same skills. I've never said no to any mediation I've been asked to do, and it's been very exciting because I'm not bored. I've said yes to every mediation. All these different venues were really fun for me. And now I train a lot. So that's a different venue in itself. I just trained last week judges and lawyers from New York City. Very exciting. Next slide, please. And now I'm here today in Pakistan, which is an honor and a pleasure. Very exciting. Think about the type of mediation that you'd like to do, or think about never saying no to when you're asked to mediate someday. The challenges of the future of mediation are giving it its due honor. For instance, every company's contract should have mediation before arbitration. People deserve to have the honor of sitting around the table and trying to make good decisions for their lives in the workplace, wherever it all is, before a third-party arbitrator, a third-party judge is going to tell them what to do, is going to make a decision they must abide by. Or you have to wait for your justice to happen in court for 10 years, 15 years, 20 years. We don't wait that long in the United States, by the way. We can have a family divorce judgment in the United States in 6 months. That's not true around the rest of the globe. Mediation needs to have its due honor. It needs to have its opportunities. It needs to have its formal legal future. It's very important. It's much more relaxed with people if they can sit around the table and talk about, just as the ancient traditions back to Plato and Aristotle, people sat around and discussed. I don't know how we lost this, but we did somehow. Now it's coming back. Let's sit around and discuss and bring these decisions to the legal system we must abide by. The expertise demand of great mediators, good mediators. Mediators should volunteer first to get good at their craft. Your way, your mediator style, your mediator confidence, your mediator courage. You can copy and paste Kathleen, but I'm not Muhammad. Muhammad needs to mediate his way someday. And he's going to be great at it because he understands that his style is important as a mediator, just like my style is me. I'm running the process. I'm the most important person at the table. Muhammad's going to be the most important person at the table someday. Hamar as well. The most important person because it's your mediator style, confidence, and courage, as I always say. So this demand of expertise of running a great mediation and being great at it and having a high settlement agreement rate, 97% agreement rate, 99% agreement rate, that settlement agreement rate is for people at your table. It's not for us for bragging rights. Although proud, yes, I am. It's for the people at the table to move forward with a due difference and a new future forward. It's for them that I want to be good at what I do. It's for them that I want to be an expert at running the process. I don't miss body language. I don't miss any emotional tenor. Someone rolls their eyes at my table like this, roll your eyes, cock your head. I'm going to be asking, Muhammad, you just rolled your eyes and turned your head to the side. Can you tell me more about my expertise in noticing? That's going to be in great demand someday, and we're all going to have to be really good at this. If we want this to have its expert due honor in the legal system, lawyers train for years to have their expert due honor in the legal system. Mediators, we have to be good at running our process with our structure and with our flexibility as we conduct the mediation process from A to Z. Moving forward, our next slide, which might be close to our last slide. The professional scope of mediation always starts with volunteering. So please join your ADR society in college. Please volunteer for your law school mediation tournaments. All mediators must volunteer because we're not good at it, because we get good at mediating, actually sitting at the table mediating. And these law school mediation tournaments, you get good at mediating because the role plays are put forward as a real life situation. I'm coaching a team right now that's going to be in Vienna this week and next week. And we are looking up all the real information on Google, making sure they're experts and what the case is about, making sure they know what to do, making sure my mediator's trained in great mediator skills with tools. We need to have significance by being good at what we do. And after you volunteer, then you look for those career opportunities. You can shadow mediation centers. You can join mediation centers. Ask a lawyer, a barrister, an arbitrator if you can shadow them. The practical insights are step into the field. Find your place to volunteer. Find your place to be mentored. Find your place to get good. And the first place you already have is in your law school. Or join TMI, Teen Mediation International, and you can practice role plays. And I'll put that into the chat at the end as well. Okay, next slide, please, as I finish up here. There are mediation tournaments happening across the globe where you don't have to be in law school. You can be a law student, you can be a high school student, you can be a middle school student. So let me put into the chat right now, Teen Mediation International, and go ahead, any questions?
I presume that they also, I have just one question, that the competitions you're talking about, I presume that they don't require the mandatory 40-hour plus which you need to take for the ADR as well. Well, that's not mandatory for them. for to participate in the competition.
Correct. It's not. The 40-hour basic training is when you want to enter professionally to make money as a mediator, but you still should volunteer because learning to mediate is it's difficult to get great at it. It really is difficult and it takes practice. So here are the tools I'm putting into the chat as well. You're all welcome to access this document and look at the mediation tools and start to practice them. You can practice these tools of listening to people and communicating with people in your everyday world and your everyday life with your friends, with your family, with your professionals, with fellow students. You can start to practice these tools. These are real tools that I use and teach around the globe. So have at these tools and enjoy them because these tools help people fight less, argue less, have a happier life. And these tools, nobody can take from you once you learn them. When I say, Muhammad, can you tell me more about that? That's just a tool. It's a tool question. Once I learn it, I say it all the time when someone's upset with me. Thank you, Muhammad, for your honesty, gratitude tool. Can you tell me more about that, Muhammad? Muhammad's upset with me in pretend, and I'm validating him, acknowledging that he's upset with me, giving him autonomy and agency. This is what happens at the mediation table. I can do that with Muhammad. If him and I are arguing, I don't have to be my own defense attorney anymore of my life. I have mediation tools that I can use now that will help Muhammad explain. And I'm going to say, thank you for your honesty, gratitude tool again. It's a mediation tool. I might not like what Muhammad is saying, but I can be respectful to Muhammad. And then I can say, Muhammad, may I speak now? May I share what I'd like to talk about? Are you ready to hear me now? These are all mediation tools. So thank you, everyone. This has been very enjoyable. I appreciate it. I hope everyone's enjoyed this session.
Well, thanks a lot, Miss Kathleen. I really am astonished by the way you are explained this, the way you have delivered the lecture. It just felt like that you are in front of ourselves rather than this virtual boundaries of virtual connection. You have broken the physical barriers via your explanation. So it's a very great experience, I would say.
Thank you.
So we would be moving towards question now. So it is requested by the participants to comment down the questions so that I can share it with Miss Kathleen and she would try her best to answer those questions. Yes, guys, drop down your questions so that I can share it with Miss Kathleen.
Well, if there are no
Well,
questions,
Miss Kathleen, we have a question from Mr. There are questions.
Okay.
So there's a question that from your experience with cross-border disputes, what is the biggest cultural or legal difference that makes international mediation harder than domestic mediation? How do you handle it?
I have noticed that in cross-border disputes, paying attention to culture is very important when people come join together. And I also have friends that are at a very high level of cross-border disputes. One of the necessary components of the mediation table is that people want to do something different. Oftentimes with the cross-border disputes, people want to stick to their traditional meaning. Remember we talked about meaning, Muhammad? People bring meaning, historical meaning to the table. Well, cross-border disputes get into trouble because people want to retain that historical meaning and have a hard time doing something new because the culture is so embedded. They can be difficult. cross-border disputes. And that's why we have a mediation, then we have a war again, then we have a mediation, then we have a war again. And I'm like, what's going on with all these cross-border disputes? My friends that are at that level, I am not at that level usually. And they simply tell me people really don't want to do something different. So we have to have a heart of change inside of us. Doing something different will create a change in someone. And that's the issue with cross-border disputes. There are so many vested historical interests and meanings that don't want to change at the table. It just makes it so difficult. And we can see that in the world. I mean, look what, unfortunately, apologies, look what's happening with the United States right now. We just want things our way. And it makes it very difficult. Makes it very difficult. Another question?
Well, we have another question that the rise of online dispute resolution and AI in legal technology. How do you see the traditional role of a mediator evolving over the next decade?
AI is very important. You can create videos of public information with AI. You can create mediation summaries with AI. You can create settlement agreements. AI makes things broader, larger, faster, more professional. But you have to remember AI at the mediation table. Remember, mediation is confidential. I'm still taking handwritten notes, Muhammad, because my AI platform, who's running the platform, if I put all my mediation notes into the Zoom chat and then save it to the cloud, somebody else can have access to that. So I'm sticking to the old-fashioned way. But you have to be careful that the AI platforms have extreme confidentiality. Otherwise, I don't recommend that you use the platforms for the conversation, but I do recommend that you use AI for document creation in items like that. Next question.
Exactly. AIs are they are getting very much insecure nowadays. So the next question is that does switching a mediator into an arbitrator ruin trust by forcing parties to hide secrets, or is it the future of dispute resolution?
It seems like it's trying to be the future, the med-arb, mediation arbitration, or arbitration mediation. It's going to require a mediator that can really turn off their feelings and insights they've gained at the mediation table, and then left brain stick to the facts only within the arbitration environment. That's going to require a mediator that can totally turn off the bias or prejudice towards someone or away from someone, and sanitize themselves, sanitize their mind and their human feelings that happen during the mediation once they get to arbitration, especially if mediation is first. Now, if you arbitration first, then mediation, that's a little easier. But if mediation is first, if it's med-ob, they're going to have to sanitize and just like sanitize their mind and become logical only. It's quite the skill. Next question.
Indeed. Next question is that which type of mediation you felt impossible?
I'm sorry? Can you
Which
repeat
type
that?
of mediation you felt impossible to do so? Which
I,
type of mediation you felt impossible?
I don't think any type is impossible for me. I like them all. I will do evaluative mediations. I will do settlement conferences. I like them all. It's just I run them almost the same. I'm still the same mediator no matter the venue. So I think the facilitative is the best one to learn because it teaches you to pay attention to justice, injustice, emotional tenor, body language, and then you bring all those skills with you when you go to all the different types of mediations. Because I notice everything. Facilitative mediators, we notice everything. Chasing clarity and accuracy.
Next question we have that in your view, what are the biggest barriers preventing mediation from becoming the primary dispute resolution mechanism?
The biggest barrier is that we don't have a place to practice to get good at it. And the second biggest barrier are that lawyers don't want to give up their revenue stream to let a mediator make money taking care of the case instead of lawyering the case. So there's a couple big barriers out there, and they are both understandable. But we have to learn to play well with others in the world of justice. So I think we all should start to get along. Thank you.
Okay, so next question. Let me just see. I guess the questions have been yes. How to build communication skills? It's very necessary in all fields. Can you give me an advice to pursue best communication skills?
Yes, skill number one, and it's in my toolbox. If you all go to the chat and click on my toolbox, the mediator toolbox, you'll see it saying thank you, gratitude tool. Skill number two, can you tell me more about that? Is a question. Can you tell me more about that? Those two skills open up communication. So just practice those two. And then the other skills are located in the mediator, my CAM mediator toolbox document.
Okay. So next question is that in what ways does the transition from adversarial litigation to commercial mediation shift the focus from legal rights to commercial interest?
And adversarial litigation is it's supposed to be that way. Litigation is supposed to be adversarial. I tell people all the time, we all need our heroes. We all need our gladiator to fight for us. The court process is supposed to be adversarial. But remember, the court arena, a gladiator arena, we have a winner and a loser, just like in the Roman gladiator games. There's a winner and a loser. It's the same in court. Maybe sometimes the judge will split the difference. Arbitration, the same thing. We have an arbitrational award, a partial award. We're getting awarded. The mediation table isn't like that. The mediation table is different. Everyone gets to make decisions that look like a win-win for their lives. It's a whole different venue. I don't want to change the courts. People deserve, if they can afford and wait, and they can wait long enough for their justice, people deserve the right to go to court. Going to court is a right. It's not a punishment. Thank you.
So next question we have is that how is artificial intelligence currently being integrated into online dispute resolution platforms?
I mention that softly because I only use it softly. But again, it's about writing out the settlement agreements, maybe creating a video that gets, in the lawyering field, that gets sent to the other client. Only public document information can be on it. But you can do all these creating of tools that you need. Maybe your settlement agreement, maybe your mediator's opening statement, maybe the agreement to mediate comes from AI. I use AI when I'm writing. It changes my writing, but you have to interact with AI. You don't want AI to do everything. You want to interact with it like it's a person. That gives you the best benefit. Otherwise, your own brain will start to shut down a little bit because AI is doing all the work. So treat AI like a person and then just interact with it. Thank you.
Thank you. The next question is that should mediation be made mandatory before filing certain categories of civil cases, or would that undermine the voluntary nature of the process?
If you have the spirit of mediation inside you as a mediator, when there's a mandatory mediation, it's because the courts need help. I don't mind helping the courts, but what I say is, thank you for keeping the court appointment. Depends where you are, what the mandatory mediation means. You have to keep an appointment and show up for mediation, then you're free to leave. That's voluntary. So I just ask people, I say to people, the gratitude tool, thank you for keeping the court appointment. Would you like to stay and discuss? That's when their voluntary comes in, Muhammad, their autonomy. Everyone says yes. But some states you have to write a report. Some state to the judge, to the court. Some states you have to explain, did people mediate in good faith? And if someone doesn't mediate in good faith, they get to the court and the judge yells at them and says, how come you didn't mediate in good faith when you had a chance to discuss this in mediation? So it gets a little crazy. It's going to be the way the mediator handles it, whether it undermines the voluntary nature of the process or not. But we're just helping the courts And I don't have a problem with that. But I guess you could say it potentially undermines the voluntary nature of the process. But again, I think it's the way the mediator handles it. Thank you.
Sure, sure. So the Q&A is done. I just need to take one last personal question of mine. That
Hmm.
we have discussed the pros of the ADR competitions and the ADR mechanism, all those things. So what are the cons of this process?
Ask that again, please.
I was saying that we have discussed the advantages largely about the ADR, the concept of dispute resolution or the mediation. I'm asking about the disadvantages, like what are the drawbacks?
Okay. One disadvantage of the mediation settlement agreement is if the settlement agreement does not have consequences built into it. Because the settlement agreement says you should do this, and it needs to have consequences built into it, and it needs to have court action built into it as well. So if the mediation falls through, people can take the other person to court. So we need to have consequences in attachment to the court in settlement agreements. That's one disadvantage that people are not doing at the table. And that comes from the mediator. Another disadvantage of the mediation process is a mediator that either has too much structure. Remember, process equals structure plus flexibility. Too much structure and is telling people what to do, and too much structure squashing the feeling of justice at the table, or too much flexibility. Too much flexibility is disorganization at the table. Oh yeah, oh yeah, yes. You want to do this? You want to do this? No. We need the law for structure. We need the process for structure. And then we can be flexible off of the structure. So if you've got a mediator that's too structured or too flexible, that's a huge disadvantage. Very confusing, having settlement agreements that don't even work. As soon as people step out into real life, it falls apart. And also look at the country that we're in. I'm a woman. How much power do I have in particular countries around the world? How can I sit at the mediation table with equal power and then walk out of that room into my culture and not have any power, or have less than power? So we have to be careful about the deals that we broker at the mediation biosphere of everyone having power, when people are walking out into a dominance one-up society. Those are the problems at the mediation table that I tap into as a mediator. That's a great question, my friend. Thank you for it.
Thank you, thank you. So I guess the questions have been done. So once again, thank you, Miss Kathleen, for addressing the questions and for sharing your valuable time and knowledge with us. So it was a very much great experience, and I hope you have would have enjoyed it as well. So I would also like to thank all participants for their engagement and cooperation throughout the sessions. The questions were really insightful as well, and this was showing that you people were paying the attention. So thanks to you all, and once again, thank you, Miss Kathleen.
You are very welcome. Much love to everyone. And I hope that everyone has a wonderful day or evening, rest of your evening. Good night.
Well, we would be having night. We would be having night ahead.
Yes. I have day, you have night. See behind me the window, I have day. Bye bye, everyone. Much love.
Well, wish you a good day. So thank you all. That's it. Allah Hafiz.